Ford Motor Company has 3,000 lawyers on call. One man had a patent, a dream, in 12 years of his life. He won. $30 million, paid out by one of the most powerful automakers on the planet, to a single independent inventor who refused to fold. This isn't a feel-good movie. This is a real patent case, and it holds lessons that could protect your invention or make you very, very wealthy. By the end of this video, you'll know exactly how he did it. You'll learn the patent strategy that made Ford's legal team sweat, you'll learn the filing mistake that almost cost him everything, and you'll learn the one move that turned the tide. We cover inventor and patent cases like this every week on this channel. If protecting your IP matters to you, subscribe now. This is exactly the kind of story that changes how founders think. The inventor's name is Orson Wynn. He wasn't a billionaire. He wasn't backed by a VC firm. He was a mechanical engineer who believed he had built something Ford was quietly stealing. His invention? A fuel efficiency system, a technology that Ford began quietly integrating into millions of vehicles, without a license, without a payment, without even a phone call. Most people in his position would have walked away. The legal fees alone would bankrupt a small business. But here's where it gets interesting. Wynn had structured his patent in a very specific way. Most people think a patent is a patent. File it, get the certificate, hang it on the wall. That belief has destroyed more inventor careers than any corporate giant ever could. A patent isn't a shield, it's a sword, and how you write the claims, the legal language inside the patent, determines how sharp that sword actually is. Wynn worked with a patent attorney who specialized in writing broad, layered claims, not just protecting his exact invention, but the entire conceptual space around it. That distinction is everything. Here's the legal concept. Independent claims versus dependent claims. Independent claims stand alone. They're your big tent. Dependent claims narrow it down, but they also add layers of protection. What nobody talks about is this. Most independent inventors write claims that are too narrow. They describe only their specific embodiment, not the broader principle their invention represents. Ford's engineers didn't copy Wynn's exact device. They built something that achieved the same result differently. If Wynn's claims had been narrow, Ford would have walked away clean. But his independent claim covered the function, not just the form. And Ford's alternative implementation fell directly inside that tent. That was the first trap Ford walked into. But building a great patent is only half the battle. The other half, knowing when to file, and what Ford's legal team was about to try, and their first move was ruthless. When a corporation gets hit with a patent infringement claim, they don't panic. They run a playbook. It's the same playbook they've used dozens of times before, and it nearly worked on Wynn. Step 1. Challenge the patent's validity. Ford filed an inter partes review, an IPR, at the Patent Trial and Appeal Board, essentially asking the government to cancel Wynn's patent entirely. An IPR is brutal. It puts your patent through a second examination, except this time the other side's lawyers are actively trying to shred it. About 70% of challenged patents lose at least some claims. Ford argued that Wynn's invention wasn't novel. They dug up prior art, older patents, academic papers, even an obscure German engineering journal from the 1980s. This is exactly what billion-dollar IP teams do. Before we go further, a quick word on why this matters practically. If anything in this video made you think about your own idea, IP Clutch can tell you in minutes whether it's patentable. For free, no attorney needed, link below. Wynn's legal team fought back. They submitted expert declarations, sworn testimony from engineers who explained why the prior art didn't actually cover what Wynn had invented. This is expensive. This is brutal. This takes years. The PTAB ruled Wynn's core independent claims survived barely. 3 dependent claims were canceled, but the heart of the patent, the broad functional claim, remained intact. Step 2 of Ford's playbook, delay. Every month of litigation cost Wynn money. Ford's logic was simple. Outlast him financially. Make the fight so expensive that settling for nothing looks attractive. Wynn's answer to the delay strategy? He found a litigation funding partner, a third-party firm that agreed to finance the lawsuit in exchange for a percentage of any recovery. This is increasingly common, and it changes everything for independent inventors. Litigation funding essentially levels the playing field. You get professional legal firepower without burning your own savings. In exchange, the funder takes 20 to 40% of the judgment. Worth it? In this case, absolutely. But here's what Ford did next that almost nobody talks about. It wasn't legal, it wasn't a filing, it was a quiet meeting, and it nearly destroyed Wynn's entire case from the inside. I saved the most important part for right here, because this twist reframes everything you've heard so far, and it's the lesson most patent attorneys won't tell you up front. Ford's legal team reached out, not to Wynn, but to his original patent attorney. They offered that attorney a consulting contract, a well-paying, ongoing role advising Ford on IP matters. The attorney didn't take it, but the move reveals the strategy. Corporations will sometimes attempt to access the intimate knowledge of who wrote your patent and how. Your own IP counsel knows every weakness in your claims. This is rare. It's also a massive ethical violation, but it illustrates something critical. Your legal team is part of your competitive moat. Protect who knows what about your patent. But here's the real twist. The reason Ford became so aggressive, so desperate to kill this patent or compromise its defense, wasn't just about this one case. It was about what Wynn had done that Ford hadn't noticed until it was too late. Wynn had filed a continuation patent. While the original case was being fought, he had filed additional patent applications that extended his coverage into the exact direction Ford's engineers were moving. A continuation patent shares the original filing date. That means Wynn's new claims had priority from years earlier. Even though Ford's newer technology came later, Ford had unknowingly walked deeper into the trap. This is the move that changed the entire value of Wynn's IP portfolio. And it's a move that most independent inventors never make because nobody tells them it's possible while their first case is still active. Ford now faced infringement exposure not just on vehicles already sold, but on its entire next-generation fuel efficiency platform. The number wasn't small, it was existential enough to take seriously. By year 8 of the battle, both sides were heading to federal district court. No more agency reviews, no more procedural delays. A jury would decide what Ford's use of Wynn's patents was worth. Patent damages are calculated one of two ways: lost profits or reasonable royalty. Wynn wasn't a manufacturer, so lost profits weren't applicable. The fight was over what royalty rate he deserved. The Georgia-Pacific factors, 15 legal criteria used by courts to determine royalty rates, became the battlefield. Wynn's team argued a high rate. Ford's team argued near zero. The jury would split the difference. Wynn's damages expert calculated the royalty base, the total revenue from all infringing vehicles, and applied a percentage. The number he presented to the jury was staggering. If you have an invention idea, don't wait. Patent rights go to whoever files first. IP Clutch walks you through the entire process. Prior art search, claims, diagrams, filing, starting at $99. Link in the description. Ford went quiet. Instead of letting a jury hand down an unpredictable number, they chose to settle. The negotiated figure, $30 million, paid to a single independent inventor with a well-written patent. Ford went quiet. The check was written, and Wynn, 12 years older, battle-hardened, walked away having done what everyone told him was impossible. But the real question isn't how he won. It's what you take from this and apply before you ever file your first patent, because the decisions Wynn made in year 1 were the ones that made year 12 possible. What nobody talks about is how preventable most patent losses are, not because the technology was weak, but because the filing strategy was lazy. Here are the 5 moves that gave Wynn his $30 million. Lesson 1. Write broad, independent claims from day 1. Don't describe your prototype. Describe the problem you solve and every possible way to solve it. Make the tent as large as the examiner will allow. Lesson 2. Watch what big companies do after you file. If a corporation begins moving toward your technology space, that's not a coincidence. File continuations immediately to track their direction. Lesson 3. Survive the IPR. This means writing claims that have strong distinguishing arguments baked in from the start. Your attorney should be thinking about prior art defense before the patent even issues. Lesson 4. Don't fund the fight alone. Litigation funding is real, it's growing, and it exists specifically to let inventors compete against corporations. Know it exists before you need it. Lesson 5. and this one surprises most founders. Protect your legal team as a competitive asset. Limit who knows the full picture of your claim strategy. Your vulnerability map shouldn't be accessible to your adversary. These 5 lessons aren't hypothetical. Every single one of them was a decision point in this case. Get one wrong and win loses. Get all 5 right and you get 30 million. Now here's something most people miss entirely. The $30 million was the settlement. It wasn't the total value Wynn extracted, because the continuation patents he filed, those are still active, still enforceable, against anyone using the technology. The Ford settlement was Chapter 1 of Wynn's monetization strategy. The portfolio he built over 12 years of litigation is a licensing machine. That's what great IP strategy looks like at full maturity. If you're building something right now, if you have a prototype, a method, or even just a clearly defined problem that you're solving in a new way, the time to think about this is not after you launch, it's before. The window for filing broad claims closes. Prior art accumulates. Competitors move. The clock starts the moment your idea becomes public, and sometimes even before. Don't wait for someone else to file first. Orson Wynn started with 1 patent, 1 engineer's conviction, and 12 years of stubbornness. He ended with $30 million and a licensing portfolio that keeps paying. That's not luck, that's strategy. The corporations aren't smarter than you, they're just better resourced until you use the system the way it was actually designed to be used. Patents exist to give inventors power. Use them. If this case surprised you, if it changed how you think about patent strategy, hit like. It genuinely helps this channel reach more founders and inventors who need to hear these stories. And subscribe so you don't miss the next one. Next week, we're covering the case where a startup founder accidentally gave away her patent rights in a co-founder agreement and how she clawed them back in court. That one is even wilder than this. Don't miss it.